Went through the torture log and she marked it up with different coloured pens, and she came back with a sort of multicoloured version of the document that I'd given her. And in blue, she marked indicators of distress. And the document was absolutely chock-a-block full with what she called indicators of distress. And I said, well, is it torture? What do you think? She was very careful. She was very prudent. She said, well, I would obviously need to examine the guy. I'd need to talk to him to form a view. But frankly, if you were to take 12 clinicians and put them in a room and ask them, was this guy tortured, they would all say yes.
Can you talk about Douglas Feith, who he was, his significance, your extended interview with him in Washington?
I can talk to him. It's one of the great things about America. My own country is not so open, but you can just get in touch with people, call them up, email them, find their spouses and partners and say, can I come and talk to you? And Mr. Feith said yes, and I'm very grateful to him for that. He's a rather flamboyant character. Someone described him to me as sort of an energizer bunny. He likes to speak. He's got a rather big opinion of himself and the role that he played. He talked rather frankly, I think probably too frankly, about his role in all of this, and in particular he had an absolutely crucial role in being the person who drafted the memo for President Bush, which caused the Geneva Conventions to be, if you like, suspended from application at Guantanamo. On the 7th of February 2002, President Bush adopted a decision that none of the detainees at Guantanamo would be able to rely on any protections under the Geneva Conventions, including the prohibition against cruel, inhuman, degrading treatment or torture. And Doug Feith described to me how he and General Myers worked together, and that he in particular took the steps to ensure that none of these detainees could rely on Geneva. And I put it to him, isn't the consequence of getting rid of Geneva that there's essentially a blank page? All the constraints on abusive interrogation are gone. And his response was, that was precisely the point. And I thought that was rather telling, because the administration has never owned up to the fact that the reason they disapplied Geneva was precisely to open the door to aggressive interrogation.
He was Undersecretary of Defense. Now he...
Well, he was Undersecretary of Defense in charge of policy. So here I am talking to the guy who's responsible for US policy on treatment of detainees. And I put it to him, did it never occur to you that by opening the door to this type of interrogation, you would expose American soldiers or Americans to the same sort of treatment? And he really just didn't... He basically said, we never really thought through all of these issues. It was rather shocking.
And the role of Dick Cheney in all of this, and in your research and interviews with the various principals that were involved? Well,
if he had a role, and it's pretty clear that he did, because he's the famous dunk in the water quotation, he's got no objection to waterboarding, it seems, if it's going to produce results under certain circumstances. His man was a guy called David Addington. I didn't meet Addington. He doesn't give interviews. I met his protege, Jim Haynes, with whom he worked very, very closely. Addington was plainly the man who was driving the issues forward, and one assumes he wasn't doing it on his own behalf, but on behalf of his boss, who was the vice president. Diane Beaver described to me, that she was fearful of this man. He was a big, powerful man, a booming voice, a big beard that he had, and he was obviously the man in charge. It is plain from a lot of accounts that I've got from people who dealt with him directly, who were bullied by him, that he was the driving force. He has no... I mean, frankly, it's a combination of ideology and incompetence. These people were driven by an ideology of getting rid of rules that constrained the freedom to interrogate aggressively, and incompetence, not thinking through whether or not these interrogations would have consequences for the United States. But most significantly of all, and this in a sense isn't in the Vanity Fair piece but will come out in the book when it's published in 3 weeks, they didn't get anything out of this guy. It was a hopeless exercise.
Philippe Sands, the memo that came out this week that endorsed assault, maiming, even administering mind-altering drugs, the document suggests U.S. interrogators would be immune from prosecution for any crime because of the president's wartime authority. What about the possibility of war crimes being filed against the highest levels of the Bush administration, and how high would those levels go?
Well, that argument is complete rubbish. When you violate an international criminal law like the Geneva Convention or the Convention Against Torture, you expose yourself to the risk of criminal investigation or prosecution. That was dealt with by U.S. federal law. In June 2006, the Supreme Court gave a judgment in a very famous, very important case called Hamdan versus Rumsfeld, and they said the administration got it wrong. The administration, by deciding that no detainees had rights under Geneva, had violated US constitutional law. Justice Anthony Kennedy put in a separate opinion. He was with the majority, and he opened the door to war crimes possibilities. He said this means that war crimes violations may well be investigated in relation to situations in which the Geneva Convention was not followed. The administration recognized the threat that it faced, and within 3 months it had adopted legislation in the Military Commissions Act which created an immunity for any person who was involved in the interrogation of al-Qahtani, as well as many other people. That immunity applies within the United States, but as I write in the article in Vanity Fair, it doesn't go beyond the United States. And I describe in the Vanity Fair piece, and in much more detail in the book, the meetings I've had with a European judge and a European prosecutor, who basically said the fact that the US has created a domestic immunity significantly increases the prospects of international investigation or prosecution if any of these people set foot out of the country. And as the prosecutor said to me, that was a very stupid thing to do, to create an immunity.
So in essence, your sense is that it's a very real possibility that in the future some of the individuals involved could be exposed, at least in foreign countries, to prosecution for their acts.
I think it's a real possibility. The judge and the prosecutor have asked me for all of my materials. They were not aware of the details. They were not aware of the immunity that had been granted. And I think what it does do, at the very least, is expose some of these individuals, including the lawyers who form part of what I've called the torture team, to the possibility of investigation if they set foot. Well, they're going to be investigated irrespective of whether or not they set foot outside the United States. The possibility of the tap on the shoulder, what happened to Senator Pinochet when he was in London, I think becomes a real risk in relation to some of the individuals at the top.
Nazi attorneys being tried for war crimes?
Well, this is a delicate issue. I obviously went back to examples. I wanted to find examples in which lawyers had been prosecuted for international crimes for carrying out their professional activity of being a lawyer. There's really only one case that deals with that, and it's a case called the United States versus Alberto. And ironically, it's a case that was prosecuted by the United States, by the US military, which I have to say comes out of my investigation squeaky clean. I've been bowled over by the integrity, the professionalism, the decency of the career military lawyers. But in the case of Alberto, he and 11 other lawyers in Germany in the 1930s and 1940s were indicted. Alberto spent 5 years in prison for essentially knowledge of criminal acts of a criminal organization of which he was a member, the SS. I'm not for a moment drawing the analogy between President Bush and Hitler or anybody else like that, nor am I saying the United States is Germany in that period. I'm interested in the analogy of principle. When does a lawyer cross a line? When does a lawyer do something? And when a lawyer invokes an example of national security, as Jim Haynes did, to override a clear obligation under the Geneva Conventions not to torture someone, not to abuse someone, they have taken themselves, on the principle established by the US military in Alberto, into the territory of criminality. And the arguments made by Mr. Alberto and Mr. Haynes, in a sense invoking national security to justify the unjustifiable, are analogous.
Philippe Sands, I want to thank you very much for being with us. His piece is in the latest issue of Vanity Fair called The Green Light. His book on the same subject is coming out in just a few weeks called The Torture Team. This is Democracy Now!, democracynow.org, the War and Peace Report. As we turn to our break, which is music sent in by a son of a man who's very ill right now in Tucson, Arizona. And as they talked, the son said to the father, as they talked about what they could do about the world today, "Why don't you just write a song? You've been playing guitar since you were a boy. Write a protest song." This is it.
Everything I know that you lie. And I know every time you speak to me, you lie. And I know you don't have tell you everything I know. I know that waterboarding is torture, and torture is terrorism. I'll tell you everything I know.